Hey everybody, John Skiba here, and in this video, I'm going to share with you the two things that you have to do if you want any hope at all of defeating a motion for summary judgment in your debt collection lawsuit. But if this is your first time here to my YouTube channel, please go ahead and click subscribe, check on that little bell. That way you'll be notified each and every week when I provide you with a new video that'll help you deal with your serious debt problem. All right, let's talk about motions for summary judgment. If you're dealing with a debt collection lawsuit, whether this is from an original creditor like Bank of America, or whether it's from a junk debt buyer like Midland Funding, Portfolio Recovery, whoever it is that's suing you, the motion for summary judgment is the number one thing I see that trips people up who've actually responded to the lawsuit and are trying to defend against it. You know, you're going along in your lawsuit, you get served, you're nervous, you don't know what to do. Maybe you come to my YouTube channel, you talk to an attorney, whatever happens, but you draft an answer and you file it with the court. That's so important that you do that first step of actually responding to the initial complaint and summons. However, you're going along, you think, okay, I got over that hurdle, things are good, and then bam, you get a judgment in the mail, you don't get a trial date, and you're just wondering, what happened? You know, I thought I did everything right, and now all of a sudden a judgment's been entered against you. The reason that usually happens is because the creditor has filed what's called a motion for summary judgment. So in this video, I wanted to give you kind of the big picture idea of what a motion for summary judgment is, what the defenses are to it. I'm not going to go into a lot of the little tiny details of it. I've done other videos on that. I even have an online tutorial that'll walk you through how to draft a response to a motion for summary judgment. And I'll link those up down in the comments below. But this one, I wanted to kind of give you just the big view, you know, the 35,000-foot view of a motion for summary judgment so you can get an idea of what it is you need to try to accomplish in responding to it. So I'm going to give you two tips here that are going to help you to get the best possible chance to defeat a motion for summary judgment, which you must do if you want a date in court. If you want to get your day in court, if you want a trial, you've got to beat the motion for summary judgment. Collectors know this. They know that if they serve this on you, that this is going to be something that's a little more complex than the answer was, and this trips up most people. So you've got to respond to it. And that is actually my first thing. Number one thing is you must respond. In most jurisdictions, they follow the federal rule on motions for summary judgment, which requires that you file a response within 30 days from the day that they served you with their motion. And when I say served, in most jurisdictions, they're just mailing you a copy of it. But you need to look at the rules in your specific state. Most summary judgment rules are dealt with under Rule 56 of the Rules of Civil Procedure for your state. It may be different, but in a lot of states it's that way, so you can kind of look. But usually you have 30 days to respond to the motion for summary judgment before the court's going to do anything with it. The problem I see is a lot of people get it, they don't know what to do with it. It's usually a big, thick packet of documents, and they're just not sure what they're supposed to do with it, so they don't respond. In most states, your failure to respond to a motion, the court interprets that as your consent that the motion be granted. And that's why I'm saying people are going along in their case, they feel good about things, and all of a sudden a judgment shows up in the mail, and that's because they didn't respond to the motion for summary judgment, so the court just went ahead and signed it, gave them everything they're asking for, and likely threw on a few $1,000s of attorney's fees just to make things even more difficult. But responding to it, so that's your first tip, is you must respond to the motion for summary judgment. Now for the hard part. What do you say? What do you say when you're responding to it? And I can tell you, particularly with junk debt buyer cases, and that's what I'm going to focus on in this video, is junk debt buyer cases brought by Unifund, Portfolio, Cavalry, Midland Credit, National Collegiate Student Loan Trust. We see a lot of those. Any of these junk debt buyers who are saying that they bought this debt, those responses to summary judgment need to focus on a couple things. And to understand what you need to respond, you need to understand really what the legal standard is for the court to grant summary judgment. Now, summary judgment it's a powerful and drastic tool because it takes away your opportunity to go to court. Because it does that, essentially the court's saying, look, there's limited times when we're going to allow this to happen. Basically what it is, if the parties essentially agree on the underlying facts, and it's just, excuse me, a legal issue that needs to be decided by the court, that's when summary judgment is appropriate. So, and you can see how that could be a benefit to the court. If basically the parties are saying, look, Judge, we agree what the facts are. We just need a judge to apply the law to it so we know what the final ruling is. Summary judgment is not appropriate, however, if there is a disagreement as to the underlying facts, which in junk debt buyer cases there almost always is. You may not disagree that you took out the original loan with Chase or whoever you took it out with, but you do have a disagreement that the current debt buyer is the owner. And the reason why you have that disagreement is because in almost every debt buyer case, they fail to provide significant evidence to show that they're the actual owners of the account. And so you need to highlight any discrepancy or any dispute as to the facts as presented by the plaintiff. If the plaintiff is saying that they're the owner of the account, but they haven't provided any evidence to support that, that's a factual dispute that should be dealt with at a trial, not at summary judgment. If they're saying a specific dollar amount is owed, but they haven't done anything to support that, and you don't agree with it, you need to raise that issue in your response to summary judgment and say, Judge, look, there's at least two issues that are in dispute. One is their ownership of the account. They haven't proven that they own the account. And two, that the amount that they're claiming is owed, I have no idea how they even calculated that, and they're not providing us a whole lot as far as how they did come up with it. So those are the types of things you'd really need to highlight, is any factual disagreements between you and the collector. If you can do that, the court in most jurisdictions is required to give you the benefit of the doubt. They do this because, again, it's such a drastic measure. It takes away people's day in court. They have to give you the benefit of the doubt. They have to look at all the evidence in the light that's most favorable to you as a person who had the motion for summary judgment filed against them. But if you can clearly articulate what those disagreements are as to the underlying facts, most courts will deny a motion for summary judgment, give you your day in court, and require the debt buyer to prove their case. I hope that's helpful for you today. Again, I'll put some links down in the comments for other videos that I've done that are more detailed, and even that tutorial that I put together that kind of walks you through the entire process of drafting a response to summary judgment. Hope that helps. Thanks for watching.